heard application and appeal in the matter of Afan Valley Ltd and others, and Lupton Fawcett.
Yes, good morning. Can I express my thanks on behalf of my clerk for your solicitors having sent somebody to put the tabs in my bundles, which is actually very helpful. Thank you.
It's all, my lord. I'm glad it helped. It was a joint effort.
Yes. And I also understand that a transcript has reached my clerk, but has not yet reached the clerks to the other members of the court, but will do in due course.
Thank you. Just before we turn to the substance, I understand that we offered to add tabs to my Lord Justice Holgate's bundle. That offer was, I think, declined.
Yeah, we've coped. Thank you. Thanks for the offer.
Should I refer? Am I safe to refer to tab numbers, or because my Lord Justice Holgate may not have tabs, I should?
Well, I think we did a DIY job.
Very well. I've been there, my lord, if it helps.
I can imagine.
Not in this case, I should add, but I have been there.
Yes.
Thank you very, very much then.
My lord, I was addressing you on the fundamental problems of this claim, and I was about to address you on what the claimants themselves do and do not allege. And let me stress a number of core features of the claimant's own case. First, they accept that they received many millions of pounds of investment, some £70 million or so, from investors. That was the result of the transactions in question, the investments going ahead. To the extent it is now said, and this is the claim that is advanced, we have to repay that money, they have had the benefit of that money. Anything they have to repay, these companies, they have received. That is the pound in, pound out point. But the claimants in their claim give no credit for that at all. They say that is because, and I quote, they have lost the entirety of the investor receipts, close quotes. Well, the real question then is what has happened to that money, and why are the claimants now in such financial distress and claiming to have lost the entirety of the investor receipts? And so that the court has that reference, you will find it in APOC 5, which is in the supplemental bundle, tab volume 1, tab 7, page 221. Supplemental volume 1, tab 7, page 221, top of the page. It is framed, it is expressed within the perspective of causation. And it's if the LF advised fully, properly and competently, that's bottom left, the asset SPVs would not have lost the entirety of the investor receipts. So it's the claimant's own formulation. No credit given for residual assets at all. And allow me just to make a couple of points in passing here for completeness, so far as the question of credit is concerned. These companies are said to have purchased and refurbished at least some property. No credit is given for the value of those assets at all. Separately, my Lord Justice Nugee yesterday asked my learned friend in exchanges about the leases that the investors have had the benefit of. At least some investors have had the benefit of the lease over the property, the real estate. And my Lord Justice Nugee asked, when you are positing these potential claims by investors here, and you're framing your loss by reference to those claims, are you, the claimants, giving credit for these leases that these investors have received? You were told, yes. That is not the right answer. The right answer is no. No credit has been given at all for the leases that the investors have received. And we looked at the summary of the quantum yesterday. We can go back to it if needed, but you'll remember the spreadsheet. I remember my Lord Justice Edis having it on his computer and saying, yes, it's a spreadsheet, I have it. They identify the money that's been paid in by investors, the money that's been paid back to investors by way of coupon, and the claim is put as the difference between the two. No credit has been given for the leases that the investors had the benefit of. I would add, and again purely for completeness, that some of these investors will have had compensation from other sources, for example, claims against their own advisors. No credit has been given for any of that. I mention this in passing so that the court has correct answers rather than incorrect answers to its questions, and so that it's aware that the figures that are being postulated here, even on their face, are wholly unreliable and likely to be heavily inflated. But let me please return now.
Doesn't really help you to say
the analytical points.
that the claim is too much.
No, I take the point.
You have to say there's no claim at all.
I agree. I just didn't want you to be proceeding on a false basis based on the questions and answers of yesterday. Let me return to the analytical point. The real complaint, properly analysed, is that the money these companies receive from investors has not been used productively at all, such that they now face, it is said, a significant deficit. The question is, why is that? And the claimant's own answer, their own answer to that, is that it's because of Mr. Woodhouse's fraud. They themselves allege that that is the cause of their financial predicament. And we can pick this up, please, in the core bundle. And I will start, please, with the replacement skeleton of the appellants for this appeal. It's in core bundle tab 3. Page 4, so page 51 in the bundle, paragraph 13. In due course, the schemes failed and the various SPVs went first into administration and then latterly into liquidation, with a net deficiency to creditors in excess of £68 million, paragraph 13. And this is how the claimants put it. This was partly due to the schemes being Ponzi schemes, and there's a reference to misappropriations, and partly because the business plan was from the outset obviously and fundamentally flawed.
That raises a question which I had on reading the skeletons. Is Ponzi scheme, is there any tight definition of it? I mean, we all understand what it is in general, but it's not a term of art. It's not a legal term. What do we understand by it?
It's not defined in the amended particulars of claim. My rudimentary understanding of it, my lord, is that it's a scheme whereby investments paid in by later investors are used at least partly to pay returns to people who invested earlier.
Yes.
When in fact, the right business model, the sound, legitimate business model, is that you generate revenue organically and you use that to pay returns. And so it's a fraudulent business model. It's unviable, and eventually it will collapse under its own weight.
And it enables you to steal the initial investments and use them for your own purposes.
Exactly. And what we've said in our skeleton, and I say now, is that this fraud had 3 overlapping features. You can't separate them from one another. 3 overlapping features. On the claimant's own case, unviable, obviously flawed from the outset. And as I will show you, the claimants allege that Mr. Woodhouse, the director, knew that was the case. It couldn't be otherwise anyway, but that is their express allegation.
Why do you say it couldn't be otherwise?
Well,
I mean,
it would have to be an extraordinary. Well, my lord,
You can't just assume that,
No,
that investing in hotels won't give you a 10% return.
I will confine myself to the way that the claimants express their case. And I will show you where they do that. And obviously, I'm using their language here, an obviously and fundamentally flawed business model,
Yes.
known to be so, and I will show you where that is found. Ponzi scheme, and in a way it has, if it's obviously and fundamentally flawed,
Yeah, it really follows.
and then the misappropriation. So those are the three overlapping features.
You don't have to have a misappropriation for a Ponzi scheme.
No, I agree, but the way we've expressed it in the skeleton is that's they often
Promising a return to an investor and then not being able to pay it except by helping yourself to later investors, as you say, inevitably leads to collapse.
And so far as misappropriations are concerned, what we say is effectively similar to what my Lord Justice Edis has said to me, which is what it allows, it provides the opportunity for a director to.
And very commonly, people do extract monies from such schemes, but it's not a necessary feature.
Understood.
Yes,
Now, but I focus here on how the claimants put their case.
yes.
The schemes went into liquidation with a net deficiency to creditors in excess of 68 million, partly due to the schemes being Ponzi schemes, partly because the business plan was obviously and fundamentally flawed.
Yep.
Neither of those things, which are said to be causally, it is the language, partly due and partly because, it's the language of causation, neither of those things are said to be within the scope of my client's duty of care. Very important. We are not said to be responsible for either of those things. My Lord,
Or to put it another way, neither of those things have anything to do with whether it's a CIS or not.
correct. Yes. And we can see the same point. This is not a one-off, the way that's expressed in the skeleton. If we turn to the original PTA skeleton, please, same bundle, tab 2, page 23, first page. Paragraph 2, C's are 43 companies who were the vehicles for and thereby the victims of a substantial Ponzi fraud. And then this language, as a result of the fraud, I stress it's the language of causation, C's are all now in liquidation with a deficiency to creditors in excess of 68 million. My Lords, that's the claimant's own case. And a point, and again, in passing, they claim, there is a claim in the particulars of claim 8.5, we've not been addressed on it, but there is a claim for the insolvency and liquidation costs.
That was abandoned below, wasn't it?
There was certainly the claim for loss of profit was abandoned below. I'd have to trace back the liquidation administration costs, but plainly on their own case, it's not just the deficiency to creditors, but it's the liquidations and administrations also that have been caused by the Ponzi scheme stroke fraud.
I understood that on this appeal we were only concerned with the questions of the 68 million
The investor receipts.
and compensation.
Very well.
But if I'm wrong about that, then no doubt Mr. Pickering will tell me.
So, my Lord, the claimants themselves use the language of causation, and we can see the same arises if one looks in the pleading. If we turn up, please, the supplemental bundle, volume 1. I will give you a page number in a moment. It's page 160 of the bundle, please. Paragraph 64. My Lords, you should see the language, the true nature of the schemes. we here have what is said to be the true nature of the scheme. 64. Further, the schemes in fact operated by using the investor's money from later investments to pay the returns on investments which had been made earlier in time. So I think there is an identity of understanding about what a Ponzi scheme is.
Yes.
In particular, the schemes did not trade profitably, but were operating together as a Ponzi scheme, whereby unachievable investment returns for existing investors and so on.
Then you've got the 65, the first line.
Exactly. And we've got, despite raising 68 million, not one of the schemes involving the asset SPVs ever returned a profit. Again, nothing to do with us, not alleged that we are liable to warrant the success of the schemes or their profitability. And then we have the non sequitur, which is at the heart of this claim. The claimants seek declarations that the schemes were CIS. It is a classic non sequitur. And I note also here a very unusual feature of this case, which is that these claimants seek to bring upon themselves the liability under FISLA. They seek to create these liquidators the liability upon the companies which they are responsible for managing. It is an artificial construct and a reverse engineering.
I'm not sure that simply saying we want the court to decide if we're liable is anything improper. Liquidators are officers of the court that it's their duty to pay dividends to those who are properly creditors, and if they take the view that someone is properly a creditor, they're entitled to have the court say so. I don't see anything wrong in that.
I recognise that point. It's more. It reflects rather, I would say, that we have a situation where they're trying to overlay the CIS feature on top of an altogether different factual nature.
That's a different
I'm not
point.
suggesting any impropriety at all.
Yeah.
Just to be clear, maybe it's an error in my forensic presentation. And then if we read on, we return to the we then have the heading around the insolvency. But my lord, to be clear, I stand by my point that it's a non sequitur from Ponzi scheme and lack of profitability to SPVs. That's the key. That's the key point. And at 67, we then have the insolvency. It said that in around 2018, the group began to suffer from cash flow problems. The cash flow problems worsened. On 28th of June 2019, an application was made to court for administration orders by a number of dissatisfied investors who had not been paid investment returns and were concerned about solvency and about the viability of the group, of the schemes, I'm sorry. And what follows is a substantial narrative of the financial irregularities and misconduct which the office holders and investigations revealed within the group, and for which ultimately Mr. Woodhouse was said to be responsible. And these cash flow problems and these financial irregularities are wholly extrinsic to the CIS issue. And it's those irregularities and those commercial viability cash flow problems that led to the insolvencies. And it's that fraudulent conduct that is the cause of the collapse. And it's nothing to do with the scheme's alleged status as CIS or otherwise. And that is obviously, of course, squarely consistent with how the appellants themselves express the matter in their two appeal skeletons. Can I return here to another point that's made in the replacement skeleton argument for the appellants? It's a point on which you were addressed yesterday, and in which I recall my Lord Justice Holgate had exchanges with my learned friend. If we pick up the core bundle, please, and open up tab 3 for the replacement skeleton of the appellants. Core bundle, tab 3, page 56. It's paragraph 30. This is found in the context of the submissions my learned friend made yesterday on what is described by the appellants as other expenditure going forward. And it's this sentence, at 30, the schemes were always intended to make a profit, but only in the medium to long term. That submission is the bedrock of this argument that they make. But as I've shown you, my lords, the claimant's own case is that these schemes could never have made a profit at all. This submission, that is the bedrock for this argument, which was developed yesterday, is completely unsustainable and entirely contrary to the claimant's own case theory. And my lords, it was in recognition of that feature of their case theory that at first instance, when we raised the point in our skeleton argument during the hearing, the claimants abandoned the claim in the pleading for loss of profits because they recognised that these were not companies that ever stood to have made profit.
How can we decide this stage of the claim whether the companies could ever have made a profit or not?
I ask you to take it on the basis of the claimant's case.
Yes.
These schemes were doomed from the start. I'll show you that language.
I mean,
will show you the language.
I'm sure you'll come to this, but I'm not sure it makes any difference to the central point, which is whether they would or would not in any world have been ultimately successful has nothing to do with whether they're CISs or not.
I entirely agree. It's outside, I totally agree, if I may respectfully say so. It's outside the scope of our duty, one way or the other. Here, I'm just making a point, I'm just
Yes,
building
okay,
in a point
understood.
as
Yeah.
I'm on the move,
Yes,
to do with how the claimants express their position regarding the viability of these schemes, and that it makes this submission that is then developed at paragraphs 56 and 57 unsustainable. So you can draw a line through that submission because it starts from a premise which is not their own premise. My lord, standing back, the points made which I've shown you in the skeleton from the appellants and the pleading which I've shown you are a complete answer to this case. And what those statements reveal is we're asking ourselves alternative questions of loss and also scope of duty. They reveal what the real loss generating or loss causative conduct is. And it is not alleged that the collapse of the companies had anything to do with the scheme's alleged status as CIS. This is not a case where, for example, there's been a regulatory intervention causing the schemes to be wound up. It is not alleged that they have been fined by the FCA, or, as I put it to my lord, and we included this example in our skeleton for this appeal, that they have had to set up some kind of call centre to manage a statutory refund operation, and so there's a friction cost.
or even that groups of investors started alleging it was CIS and sought their money back.
Yeah, it's not exactly. There's been no run on the companies on the basis of investors coming and saying we want our money back, and then as you might get in a credit crisis, the company's collapsing as a result of that. No, it's not what happened, and it's not alleged.
On the contrary, it appears from the pleading that the investors were saying, "Where's my 10%?"
Exactly. They came in for their coupon. I use the word coupon to avoid a confusion with the word return, which could mean a number of different things in this context. Precisely, my lord. And why is that, I would add, my lord? It's the point my lord made yesterday, we've made in the skeleton. The contractual claims are always going to be more valuable here. Always. And you don't need to establish the complexities of whether it is or isn't a CIS. Not a straightforward matter to get your to put your contractual claim in. I'll come back to that. So the conduct that has, as a matter of analysis, resulted in all of this is that that conduct of Mr. Woodhouse that we've seen referred to in the appellate skeleton, the three overlapping aspects of the fraud, and none of it is within the scope of our duties. And My lords, I was going to show you, you've seen that the claimants allege misappropriations by Mr. Woodhouse, and they tried a claim in front of Her Honourable Judge Jackson and succeeded. They allege that it's a Ponzi scheme. They allege that it's also unviable from the start. I said to my Lord Justice Nugee I would show you the passages where they have alleged that the claimant, Mr. Woodhouse, knew that latter feature. Let me just show you that. If we can start, please, from my skeleton for this appeal, which is Core Bundle, tab 14. Core Bundle, tab 14, I'm at page 305. You'll see a heading in the middle of the page, Fundamental Problems to C's Case, and we explain why the schemes failed, because they were fraudulent, unviable Ponzi schemes and there were misappropriations. And if we turn over the page, we have given you references in these 2 pages that follow to the claimant's position, the claimant's stated case about these 3 individual aspects, which are, you see at 27, 28 and 29. I won't spend any longer on the Ponzi or misappropriations, but let me just show you what's said about the economically unviable. It was stated in the appeal skeleton, which I showed you at paragraph 13, the replacement skeleton, which we've quoted, and then it was pleaded, and it remains pleaded, the language in italics. And the judge below, as we say at paragraph 28 at the bottom of the page, the judge noted this characterisation of the scheme. They don't allege that we knew that the schemes were unviable, rightly so, entirely properly, nor do they allege at 30 that we were responsible for the scheme's commercial success. I'll come back to what they do allege about the scope of our duties. But let me just show you footnote 12, please, which are the similar statements around this fundamental economic unviability aspect. Now, footnote 12, we've referred to a schedule we've prepared, which I'll take you to in just a moment. We've given 2 quotes from it here. A letter from the claimant solicitors explaining that regardless of the way in which the investor monies were treated on any group basis, each scheme was fundamentally flawed. And I'm going to emphasise, such that the money invested would have been lost in any event. That's the claimant's language. And then 4 of the companies who pursue these proceedings pursued the trial against Mr. Woodhouse for misappropriations, and they were represented by Mr. O'Doherty, who's due to counsel today, and by the same solicitors in that trial. And you can see what they said in the written closings. The structure and key features of the investment schemes meant that NPD was destined for insolvency as soon as it started trading. And let me just show you, if I may, just for completeness, the schedule that we've prepared, which is at the back of this tab. It's in landscape form, and it starts at page 323. I'm just going to alight upon a few more examples. It's relevant to a couple of different points. You'll see the first entry is a witness statement from one of the gentlemen who became one of the joint administrators. And there were references there against 27.1 to significant sums being diverted away. 27.2, companies are balance sheet insolvent and heavily loss-making, in a number of instances lost marks by paper revaluations of property assets and so on. At the end of 27.4, at the very end of this paragraph, none of the schemes have delivered any genuine return of profit. And in the next entry, paragraph 28, the schemes bear the hallmarks of a Ponzi investment scheme. I'll move on. Oh yes, sorry, I was just going to show if we turn the page to 324, it's the entry right at the top of the page within the same document. Business model appears to be completely unsustainable. Now there are many more references of this kind. I'm not going to take you through all of them, but let me just show you a couple more, if I may. If we turn to page 326, this is the pleading against Mr. Woodhouse in the middle of the page, and I'm at the quote against the number 39. Further or alternatively, Mr. Woodhouse's breach of fiduciary duty and breach of trust was dishonest, to be inferred from the following facts and matters. NPD Limited and the NPD Group were insolvent, and Mr. Woodhouse knew that they were insolvent. None of the schemes for which investment had been raised had made a profit, and Mr. Woodhouse knew that none of the schemes had made a profit. So, my Lord, coming back to the exchange I had with my Lord Justice Nugee earlier, I'm referring very much to the claimant's own position. We then have an RFI response in these proceedings to questions that we asked, and that's at the bottom of page 327. You'll see response 20. I'm in the second line. LF is referred to particulars of claim stroke 64, which I have just showed you, my lords. It is the claimant's case that the schemes in the SPVs were not genuine investment schemes, were operated together as Ponzi schemes, offering unachievable investment returns to investors, which returns were paid out of investments received from later investors, and so on. And then there's a reference to CIS, but it's what the claimants do in these proceedings, which is to tack on the CIS point, to somehow elide CIS and the consequences of fraud, to make it our responsibility, but it doesn't work analytically. And then, if I may, just a couple more on Mr. Woodhouse's knowledge and awareness. 331, please. In the entry, the source is Mr. Dunhill's first witness statement dated 27th of October 2023. That is the witness statement tendered by the claimants in response to the strikeout application that led to Mr. Justice Sheldon's decision. And it's the quote from paragraph 49 within the box. If you have it, it is the claimant's case that GW, that's Gavin Woodhouse, was aware of the improbably high returns, and that the MBI group had operated and the NVP group was operating as a Ponzi scheme. So it's knowing and proceeding to market to investors on that basis. I note, my lord, you were shown an extract, I won't go back to it, but you were shown an extract of this same witness statement by my learned friend. You were shown paragraph 34.1, where Mr. Dunhill again described the schemes as loss-making property development schemes. Again, nothing to do with my clients. And then we can finish on this exercise by turning the page to 332. And you can see how the relevant claimants put the matter in closing submissions in the trial against Mr. Woodhouse. Bottom of 332, please. D, as Mr. Woodhouse, is an accomplished liar. He has consistently lied to investors by presenting to them obviously fundamentally flawed investment schemes. And then 6 brackets 1, D presented a fundamentally dishonest business model as a legitimate business opportunity. The structure and key feature of the schemes meant that SPD was destined for insolvency as soon as it started trading. Promised returns were impossible to achieve himself. So it is a case advanced by these claimants that Mr. Woodhouse knew full well that the schemes which he was promoting and selling through these companies were unviable. That's their case. None of that alleged to be within the scope of my client's duty of care. In returning to the question I asked, which is what has happened to the money, and to just finish off on that point, if we return to the pleading, we can see an example. We can see the claimants plead an example of that. It's in Supplemental Bundle, Volume 1, Tab 7, and we can pick it up at page 240.
This is A.5.
A.5, Supplemental Bundle, Volume 1, Tab 7, page 240. And I'm just showing this to you by way of example and illustration. It's the claimant's own illustration. They say it's sub 4. My lords, in a different, allow me just to make this point as a presentational point. In a different case with a shorter pleading, I would be able to turn the pages of the entire pleading with you and see how it's expressed. Now, we have a very long pleading. I don't make any further observations on that. But obviously, I'm not in a position to, and don't propose to, turn the pages of the pleading. But there's plenty of material in here that will assist the court in disturbing this appeal in my client's favour. I would respectfully submit. But let me just alight on this. They say it's sub 4 as the number of schemes grew in conjunction with this complex diversion of investor receipts. Some of the earlier schemes were effectively abandoned. For example, at the point at which MBI Clifton Moor was placed into interim management, approximately 4.5 years after the scheme was purchased, despite having raised 3.9 million investments for the MBI Clifton Moor scheme, full planning permission has not been obtained, no material construction or development work. The majority of the investor receipts received by MBI Clifton Moor were paid away to MBI Consulting, purportedly as purported loans which were subsequently written off. Investor returns were being paid from the NPD bank account, ultimately funded by investor receipts from other schemes. None of that is alleged to be within the scope of my client's duty of care. The long and the short of it is, why have investor receipts entirely gone? It is because they have either, in the claimant's case, been paid away as loans and then written off fraudulently, or because of the Ponzi aspect, namely being used to pay the coupon for prior investors. And we were rather surprised when my then friend suggested that the Ponzi aspect was unlikely to be a major contributor to the collapse and deficits in circumstances where I've shown you what the claimants have said in their 2 appeal skeletons that it was, where the pleading says it was, and where indeed in my submission it's self-evident that that's what happens with these schemes. And indeed the Chancellor, which at the time Sir Geoffrey Voss, said in HSBC and SIB, the Stanford Bank case, he observed, and I'll show it to you when we get there, that you would rather normally expect that that's what happens in the Ponzi scheme. The longer you trade for, the greater your deficit, because that's the nature of the beast. And so the submission yesterday, that don't worry about the Ponzi, that's not going to be a major problem, is, again, not a sustainable submission, I would respectfully submit, and it's what it is an attempt to diminish the effect of the fraud, to try and then characterise these losses as FSMA related when they are not FSMA related at all. And so, by contrast with a legitimate scheme, no revenue is coming in because there are no genuine schemes, no construction is taking place, there are no rooms to actually rent out to end users.
I thought in some cases there were actual hotels and actual care homes.
Well, there may have been some degree of that. Usually, my lords, with these schemes, and again, I'm really speculating is the wrong word, but making observations. Usually, what happens is that there is some of that, at least to give the impression that there is some business going on.
Well, if people were granted subleases, they must have been granted subleases of existing buildings.
No, I accept. So, my lord, what it comes down to is that the existential problems with the schemes have nothing to do with their alleged status as CIS, or indeed with the alleged commercial implications of being CIS. And when one asks, is the harm or the risk of harm for which my clients are responsible, or which falls within their duty of care, is that causally connected, or is there a nexus between that and the losses? The answer is no, because it's not any CIS related feature that's resulted in the present position, and that's the appellant's own case. Let me turn now to showing you that it is the claimants, indeed their own case, that my clients don't bear any responsibility for these matters, nor for the commercial viability of the business generally, so that I'm squaring the circle here. I've shown you what the harm is that's resulted in this position on the claimant's own case, and I'm now showing you their case on what my clients are actually responsible for, to show you that there is a clear line between the two. And we can pick this up again in my skeleton argument for this appeal. Please, core bundle tab 14. My lords, I should say I have an extremely bad habit of not suggesting that bundles be closed and put away. I just close my bundles and put them away, and then leave all.
Don't worry, I think we can manage our own bundles. There aren't 50 of them.
I'm in core bundle tab 14. And I'm back at paragraph 31 of my skeleton.
Did you say 31?
Paragraph 31, page 307.
Thank you. This is your skeleton.
It is. I'll deal with the points in turn: misappropriations, Ponzi scheme, and unviability. Misappropriations is at 31, and we've at third line of the paragraph. We have referenced the recognition by the claimants that they do not seek to blame us for the extent to which the investment monies were misappropriated. And it's expressed there, my lords, by the claimants in the language of foreseeability. I would also suggest it's not within the scope of duty either, if that was the prism through which one wanted to analyse. But that's misappropriations, not responsible for that, and it's accepted. Let me turn now to paragraph 27 of the skeleton, please. Page 306. The claimants have confirmed that it is not their case. We cite that we should have identified that the schemes were fraudulent or being operated as Ponzi schemes. My learned friend confirmed that in oral submissions yesterday. You have the references both to the transcript and the judgment of Mr. Justice Sheldon. Let me just show that to you quickly for completeness, if I may. Perhaps my lords can keep a pen or a finger in this page of the bundle whilst turning back to the judgment of tab 6. Page 75. Actually, please could we start at page 74? No, I'll correct myself. I'm sorry. Page 75. I'll start here. And at the top of the page, Mr. Pickering, KC, confirmed that the claimants were not arguing that LF should have identified the scheme for being operated as Ponzi schemes. And then at 41, paragraph 41, there's a discussion about the allegation that the claimants they were seeking to introduce, at first instance, an allegation around responsibility for advising on matters contained within SRA warning notices. My lords, those allegations were rejected by the judge, not admitted on factual causation grounds, over and above the strikeout. So they didn't get in anyway. But in the context of the submissions on that subject, it was confirmed that, I'm reading from the third line from the bottom, Mr. Pickering explained that the assumption of responsibility did not extend to auditing or investigating the schemes to see whether they were being conducted fraudulently.
You said that Mr. Pickering said something yesterday. Do you have a transcript reference?
No.
No.
I will get it for you, my lord.
This is page 145. 145 to 146.
So I'm told it's page 145, line 18 to page 146, line 3. My lords, I haven't checked it myself. I will do so. I trust my junior, but I better check that.
Thank you.
Great. My lords, so no allegation that we should have known that the schemes were economically or inherently unviable. My lords, I would add on the viability aspect, obviously no pleaded allegation, entirely properly, no pleaded allegation that we should have known or advised upon the fact that these schemes were economically unviable or doomed from the outset or inherently flawed, different formulations of the claimants. And that's very important, given those are the matters which the claimants say on analysis have led to them to be unable to meet investor claims. And it is not alleged that we owed any duty of care, so as far as concerns the commercial viability of the business model. And we can turn back here to page 74 of the judgment, paragraph 39 at the bottom of the page. This was the this is a discussion here on the part of the judge of the proposed amendments, and this is claimants seeking to introduce the allegations about the duty to advise on matters reasonably incidental, including the regulatory, legal and commercial implications arising from the issue of whether or not schemes are CIS. And it was, and my learned friend again entirely properly in oral argument, Mr. Justice Sheldon says, in oral argument, Mr. It's explained that the reference to commercial implications was a reference to the commercial implications of the schemes being found to be CIS. And my learned friend expressly went no further. And my lords, you will be aware that had it been alleged that we owed some broader obligation, that would be completely inconsistent with the authorities the court will be aware of regarding the role of solicitors. Commercial wisdom, advising on commercial wisdom, does not form part of the duty of care. That's not in dispute on this appeal. And referring to the judgment, again, for completeness, one can close on this point at paragraph 112, page 88. At the bottom of the page, and the judge noted, the duty of care pleaded by the claimants does not extend to advising as to the way in which the investment or loan monies would or could be used by the claimants, including but not restricted to misuse by Mr. Woodhouse, but including also any potential legitimate expenditure, such as sales commissions or other costs. It is not alleged we owed any duty to advise on those matters, on the spending of the money. And so the attempt to reformulate the case on appeal by reference to legitimate expenditure on sales commissions or conveyancing costs does not assist the claimants, because we did not owe any duty of care with respect to those matters on their own case. And for completeness, my lords, I note that should you wish to refer to them, we set out the authorities on the limits of a solicitor's duty in our skeleton for the hearing below. The relevant extracts, I'll just give you the reference. I'll go to a couple of the cases before my lords in the authorities bundle later. But the relevant extracts can be found, and the reference is Supplemental Bundle, Volume 1, Tab 10, and it's pages 352 to 353. And the cases include the two Privy Council decisions in Clark, Boyce and Moat and Pickersgill and Riley, which can confirm that where a solicitor is dealing with a sophisticated client, as this client undoubtedly was, they owe no duty at this stage to advise on the wisdom of the transaction. I'll come back to that point later when we come to consider the authorities.
I'm sorry, I didn't hear. No duty to advise on
the wisdom of the transaction.
wisdom. Yes.
Now, my lords, we can, just to close on this point, we can also see that the claimants have confirmed the position so far as my clients having no duty of care in respect of the commercial success of these schemes in their replacement skeleton. And can I please invite you to return to the core bundle. It's tab 3. Tab 3, it's page 56, please. It's paragraph 33. Now, in the middle of the paragraph, it is of course accepted that D2, that's us, did not warrant the success of the underlying business. Let's just pause there for a minute. That is unequivocal confirmation that the commercial success of the business, or otherwise, was not within the scope of our duty and is not alleged to be. But then we have what I would respectfully submit is another non sequitur. They say that is not the point. As stated above, if the schemes had not been unauthorised CIS, then none of this would have mattered. And they say this, if the business had failed, the risk would have been on the investors. But then they say this, but given that the schemes were unauthorised CIS, the failure of the business did impact on the SPVs, as the investors became entitled to full repayment. But my lords, the question I ask is, why does the regulatory status of the schemes change the allocation of risk so far as concerns the commercial viability of the business? It doesn't. The business would have failed for exactly the same reasons and in exactly the same way. And there is no reason, in principle, none in the authorities, the claimants advance their case on this without a single authority in their favour. There is no reason why the fact that we advise on the regulatory position at the outset should mean that we now take responsibility for the commercial failure of the business. And it's, as a matter of substance, this allegation does not stack up. And that will take me to the next section of my submissions on the fundamental problems, which is the Samco counterfactual. So I've shown you now what the claimants say is the cause of the loss and what they say is within the scope of my client's duty. And I've shown you the disconnect between those two things. And it's not a, it just reflects also, it's not a sort of pleading point, it just reflects the fundamental core reality of what's going on in this case. I'm not trying to take technical points, it reflects what is going on and what has happened. And that's the claimant's own case. Now, the Samco counterfactual, and this was explored yesterday with my learned friend. We addressed the Samco counterfactual in our skeleton at paragraph 50 onwards. We can pick it up there. Core bundle tab 14. Page 313. And I appreciate my lords will be very aware of this. It's quite right. In MBS they say, start by asking what the right answer is, what the proper analytical answer is, and then you can apply the cross-check if you want to. And it's a useful cross-check, but it's not the decision. And that's how I've approached it. I've sought to reflect that faithfully by approaching you first on the analytical basis, and then I turn to this as the cross-check. And the cross-check is, well, what if the advice given that these were not CISs? That's the ex hypothesi the advice for the purposes of these arguments, that they're not CISs. What if that had been an accurate reflection of the position? What if they had not been CISs? And it's the mountaineer's knee, as my Lord Justice Nugee said, it's all from his mountaineer's knee. And the answer is exactly the same thing as that which in fact happened. The very same transactions with investors would have taken place. The Ponzi scheme would have operated in precisely the same way. The schemes would have been inherently commercially unviable, due from the outset to Mr. Woodhouse's knowledge in exactly the same way. And Mr. Woodhouse would have misappropriated sums in precisely the same way. And so these schemes would have continued over time to generate the very same deficit to creditors as has in fact been suffered. The very same expenditure on sales commissions would have taken place. The very same expenditure on solicitors or other conveyancers' costs would have taken place. And if there was expenditure on the acquisition or refurbishment of buildings, that would have taken place in exactly the same way. Everything happens in exactly the same way. And eventually the schemes would have collapsed under their own weight in exactly the same way when they became unable to sustain the investor returns promised, and the administrations and liquidations would have followed in exactly the same way. And this confirms that the failure and the alleged losses are entirely unrelated analytically to the CIS or non-CIS status of the schemes.
Well, the only thing that would have been different is that if the schemes had truly not been CIS, none of the investors would have a Section 26 claim. On the claimant's case, they were CIS, and all the investors do have Section 26 claims. So that's the difference, and that's the one you have to address.
And I'm going there now. I recognise that, but the question is, would the position, the deficit faced to creditors have been any better?
Yes.
And on the claimant's own case, given the way they frame it, and given what they allege against Mr. Woodhouse, not just in the claim against Mr. Woodhouse himself, but in these proceedings, see the Dunhill witness statement and the other, and the references in the skeleton argument and the references in the pleading, their own liabilities to investors would have been no less in the hypothetical world I am addressing. And there are two reasons why. Either because the investors would have been entitled, as they are, to assert their contractual rights. And that is to the coupon, which was typically 10% annually for 10 years, but between 8% annually and 12% annually, that's how it's pleaded. These obligations to investors are found in the claimant's pleading at paragraphs 40 to 48. So you have the reference, 8.5, paragraphs 40 to 48. So you will have a coupon of a minimum of 80% of the investment made. And then, my lord,
You can't claim for interest post-liquidation, or if you go into liquidation after administration, post-administration, can you?
well, it's not interest, my lord, it's a contractual right to a return. It's not interest on a debt.
Oh, I see.
It is a contractual right to a payment.
Okay.
There's a conceptual difference between those two there. It's a debt. It's a debt claim. So there's a debt claim for the coupon, minimum 80% of the investment. And then there is the buyback at the end of the 10 years, which is 125%. That's the claimant's case. So at the very lowest, the contractual debt that the investor is entitled to is 205% of their investment. I accept, as my Lord Justice Nugee put to me yesterday, depending on the timing of when your claim is successful and when you are actually paid, there might have to be some modest reduction for net present value purposes, but it's never going to be significantly reducing the value of your claim. So you are going to be in the region of 200% minimum. That compares with the rights under FSMA to 100%. That's your payment in, plus compensation, which is there to compensate you for the loss of use of the money, which would be therefore interest or some other measure if you can establish that you would have invested in something else and you can prove that. In the case of Whiteley, which we've cited in our skeleton, which is in the bundle, confirms that the question of compensation under section 26(2)b is only there to compensate for actual loss, not notional loss. So your contractual...
Mr. Justice David Richard seemed to have had some doubt as to whether you could even claim interest.
He did.
But he didn't decide it. You're not asking me to decide it. No. Us. No.
Now, so the liability of the companies under contract in debt is always going to eclipse the liability under FSMA. Necessarily so. That's one reason why the Mountaineers knee scenario confirms the analysis I put. The other reason is the tort claim. Now, I give you a menu of alternatives here. The claim for fraudulent misrepresentation by Mr. Woodhouse and the companies, because the companies, with Mr. Woodhouse as their directing mind and will, have also made these fraudulent misrepresentations. They will be liable in tort. And
what misrepresentation?
I will show you how the claimants themselves put it. We turn to the APOC again. Supplemental Bundle, Volume 1, Tab 7. It's page 152, paragraph 48. Paragraph 48. This is the claimant's case, each scheme was promoted to the investors on the following basis. And it's items 3 and 4 here. Each scheme would be capable of returning to investors a 10% per annum return on each of the investments. Each scheme would be capable of repurchasing the investors' rooms at 125% of the original purchase price. But I've shown you that the claimant's case is that that was never achievable, and that Mr. Woodhouse...
Saved by way of a Ponzi scheme.
Saved by way of Ponzi.
The quotation you've given us in the schedule to your skeleton.
And I don't think it's being suggested in the pleading that the schemes were being promoted on the basis that they were a Ponzi scheme.
Oh, no.
Sorry, I'm not trying to be facetious. The way it's expressed, and with which we don't take issue with this, is that it was being promoted on the basis that these schemes were genuinely capable of sustaining these returns. And their own cases, the claimant's own cases, that they were not, and that Mr. Woodhouse knew that from the outset. So those were, it must follow, fraudulent misrepresentations by these companies, attracting liability on towards. My learned friend said, there might be problems with reliance and the like. Not at all, my lord. You don't have it in the bundle, but it's a well-known authority. Hayward and Zurich Insurance in the Supreme Court deals with that. Where you've got a misrepresentation of that nature, you can't, as the party who's made it, be heard to say that it wasn't material, and you can't be heard to say that you didn't rely. And it's and you can't say it's not realistic with respect to suggest now that that investors who invested in these schemes for these returns, no other reason to invest in them, it's an investment, did anything other than rely on representations to the effect that the investment schemes were viable. It's obvious.
I don't think Hayward and Zurich quite says that, but it does say
Maybe I
think
put it slightly too high.
there's a presumption
Presumption.
that you rely
Presum-
on something.
Materiality, I think I did put correctly, but my lord pulled me back on the reliance, the next bit. If I recall the case correctly, they refer to some of the older cases to the effect that the defendant, it doesn't lie in the defendant's mouth to challenge reliance, and then they don't conclude on quite on such a hard line basis. My lord, thank you, and I apologise for if in my over enthusiasm I put it slightly too high.
But your case is it's really obvious on the claimant's own pleaded case that anybody who invested in these schemes on the basis of the way it was promoted would have a claim in deceit, which at the minimum would entitle them to their money back less what they've received.
Money back less what? So credit has to be given for what they've received in any measure, whether it's the FISMA measure, the tortious measure, the contractual measure. So that doesn't change. And my lord, quite right, step ahead of me. What does your tortious measure entitle you to? You're entitled to rescind, get your money back, your 100%. So that's the same as in the FISMA context. And you are also entitled to, and we've quoted semprametals for this, it's not challenged, so it's not in the bundle, but compound interest would normally attract.
I'm not sure semprametals is still good law, is it?
Well, there's been debate in the Privy Council, if I recall correctly, in a case around whether the entitlement to compound interest will be automatic in fraud cases. But I'm probably not expressing that quite right. But where you are claiming, where it's a rescission claim, there's a decision of the Court of Appeal maybe 2 or 3 years ago, is it called Granville, that confirms that in the rescission context, because you're the alleged fraudster has had the benefit of the money and you are asking for it back, compound interest will typically attract. And I don't want to overstate it because I'm slightly remembering from trials past, but where the deceit claim results in a claim for rescission as the remedy, compound interest will not attract. I agree that there's been debate since semprametals. We've quoted semprametals, and we, in the context of finalising the index, we asked whether the proposition was challenged, and it wasn't. So the case wasn't. You weren't furnished with the case. But we say, my lord, you would normally expect, if it's not compound interest, some other measure of interest, or, my lord, loss of profit on the Eastern Mora type basis. But in any case, the key point is this, it's not going to be any less than the compensation which the investor might be entitled to under section 26(2)(b). What the Privy Council in the case I'm struggling to remember was saying about compound interest is if you have to plead and prove it. It's not some automatic entitlement. If the investor can plead and prove it, then they will get it. They're not going to be better off under section 26(2)(b), where you have to prove your actual loss. So that's the key point here. On the rescission, on the tortious claim, you will get your 100% back, and you will be entitled to damages for the loss of use of the money. It's not going to be any less. So 100% plus damages to compensate for loss of use of the money. And again, as a matter of first principles, it cannot be any less than what you would be entitled to under section 26(2)(b). Because even being generous to the claimant, both measures are intended to put the a victim in the position they would have been in had they not made the investment. So the tortious measure is going to be, as a minimum, no less than the FISMA measure. And just returning briefly to the contractual measure, my learned friend suggested that there was some doubt about how much investors had invested, how much they had been repaid, that it might be complicated to work this out, to try and cast doubt on this Mountaineer's Knee counterfactual. And those submissions are not correct. The claimants themselves have pleaded in the schedule to their particulars of claim with precision, and it's supplemental bundle page 273, it's the spreadsheet. They have pleaded with absolute precision the amounts that investors have paid in relation to the relevant schemes, and the amounts that they have received by way of coupon to date. It is all set out there in pounds and pence. So there is no doubt or material uncertainty of any kind as to what the contractual entitlement might be. So there is no concern here about the reliability of the analysis at all. The claimants have this information and they've had it for a long time and they've pleaded it out. And so whether one adopts the contractual analysis or the tortious analysis, the same transactions would have eventuated under Samco counterfactual, the same fraud would have taken place, the same economic collapse, the same insolvencies, and crucially, to answer my Lord's question, my Lord Justice Nugee's question, the companies would have been in no better financial position. In some ways, it is a different version of a no loss argument. What we are alleged to be responsible for did not worsen the claimant's financial position. It did not add to their burden. And that is the point we made in our skeleton at paragraph 53. And it confirms, to use the language of MBS, that the cause of the claimant's losses, the cause of their financial predicament, does not represent the fruition of the risk that it is alleged we were to guard against. My Lords, next topic, I'm going to deal now with the claimant's argument that because we are said to bear a liability for commercial consequences of the schemes being a CIS, and because it is alleged that we were aware of certain bona fide expenditure, we somehow become liable to underwrite that expenditure when the schemes fail. And there's a related point they make, which is that there is a difference, they say, between extinguishing pre-existing debts and paying debts that they say arise in the course of the subject transaction. My Lords, these aren't really, in a sense, alternative points. They are already dealt with by the submissions I have already made. But consistent with what I said yesterday, I'm trying to tackle this from every possible angle. And ultimately, my Lords will decide which angle they prefer or they think is analytically sound. I just want to make sure I've covered every angle, and if it ends up being repetitive, I'll be no doubt be told.
No, I think it is a different point. The point you've been addressing us on is, did the fact that the schemes were, as the claimants say, CIS, and you negligently failed to advise that, did that have any impact in any way on the claimant's financial position? And your answer to that is no, for the reasons you've given. That is in principle, a separate point from the pound in, pound out point, because the pound in, pound out point is that even if it was part of your scope of duty of care to be responsible for the Section 26 liabilities, actually, because they got 68 million in and have to pay 68 million back, there's no loss. And that conceptually, these are quite separate points.
I see that. The way I see it is that I put it this way: I see them as two sides of the coin. In this sense, what we were responsible for, did not cause a loss. Insofar as there are any losses, they are outside the scope of our duty.
Yes, I see.
And now, just trying to deal with the way the claimants formulate this point. So, the first point relating to the what is described as the expenditure, the immediately incurred expenditure, and the other expenditure. I'll come back to points around pleading and so on later. But the first point is, and here we do come back, my lord, to scope of duty points, is it's not alleged that my clients owed any duty to advise upon the way in which the monies would be used. I know I've made that point, I've shown you paragraph 112 of the judgment. But when the claimants now seek to claim from my clients the value of the sales commissions or other expenditure, it falls at the first hurdle because it is not alleged that we have any obligation to advise on such matters. And my lords, mere awareness of expenditure to follow does not make a professional liable for that expenditure. But for causation is not enough. It is the necessary but not sufficient condition. And you are not entitled to turn the solicitor into the underwriter of the loss. And we will see this further a little later in the authorities, including BPE. We were not advising on the wisdom of pursuing these schemes. It is not alleged that we were, and it follows that we are not liable for the commercial consequences of doing so. So that's the first answer. The next point, my lords, is this. Even on the claimant's best case, this is not put in terms of a duty to explain the consequences of capital being committed in illiquid investments or sales commissions or the like. Nowhere do you see such an allegation in the pleading. In due course, when you're considering, when you're deliberating, you'll see the purpose of the duty and what it is said we were supposed to guard against, pleaded at 165A, 166, 166A. But the highest it's put is the way it was put.
Sorry, are those references to paragraphs of 8.5?
They are.
Yes.
Sorry, Mike.
Yes.
But the highest it's put, and this is how it was put already yesterday, is that we should have advised of three key matters. That these companies were operating in an unauthorised CIS, or that there was a real risk that they were. That was one. That if you continue, you could be liable under Section 26 to repay monies and to pay compensation. In fact, there's no reference to compensation in the pleading, but that's a point for later. And the third thing it said we should have said is stop accepting investor monies. There is no case advanced that we should have been advising what to spend the monies on or what might happen if monies were tied up in illiquid investments or any of the sort. That's the second point, another complete answer. The third point is that even if that what was what was alleged, it is causally irrelevant. And this is my Lord Justice Holgate's point about the claimants setting up and effectively proving their claim on the basis of a reality that has not eventuated. Because these losses, the claimant's financial predicament does not arise because of sales commissions or because capital was tied up in illiquid assets. they were suffered on the claimant's own case because the business model was not viable. Investor investments were being used to pay prior returns as part of the Ponzi scheme, and because they were misappropriation. My lords, my clients were not responsible for that. My clients were entitled to assume that these schemes were viable in the long term. And it's normal for a business to invest in the business, to pay fees, to make capital expenditure. Nothing unusual about that. It's standard practice for a business to do that. That's how you grow a business. The question is, why did that not bear fruit? And the reason is the fraud in those three overlapping respects. This was a business that, on the claimant's own case, could never generate return. So causally, these allegations about being required to advise on the commercial consequences of the schemes being a CIS are entirely divorced from what has actually happened. There is also a further reason, if one were needed, around why these allegations about a duty to advise about a risk of illiquidity, if that's how I can go nowhere causally, for another reason. This is because on the claimant's own case, Mr. Woodhouse was very sophisticated and fully aware of the implications or consequences. I recognise it's one thing to say the schemes are or are not CIS, but Mr. Woodhouse knew that if they were, it followed that certain things might arise. And that I say that for two reasons. First of all, the claimants themselves plead that at an early stage, Mr. Green gave detailed advice on this. And they plead that it was discussed with representatives of MBI Consulting. That is pleaded, we saw it yesterday, I won't go back to it, but it's pleaded at 86J and 86N of 8.5. And then the second reason I say this is because the claimants who pursued their claims in the trial against Mr. Woodhouse also there asserted that Mr. Woodhouse fully appreciated the position. And I'll just show this to you in a supplemental bundle, volume 3. Supplemental bundle, volume 3, tab 29. These are the four claimants who pursued claims against Mr. Woodhouse. These are extracts of their skeleton for the trial against Mr. Woodhouse. And if you pick it up, please, at page 755. Paragraph 39 refers to the schemes being CIS. And at 40, you will see what's alleged against Mr. Woodhouse. Mr. Woodhouse either knew or was fully aware of the risk and likelihood that the schemes were unlawful CIS from well before the NPD Group's commencement of trading. And it goes on some length, and I can just show you the completeness, paragraph 42 at page 757. In respect of the NPD Group schemes, paragraph 42, D was aware that the explanations given to the FCA were incorrect. That's paragraph 1. 2, that the explanation given to counsel, Professor McGee, was incorrect. Mr. Woodhouse knew this. And the advice given was based on an incorrect understanding. And at 43 over the page, 43, it is clear that Mr. Woodhouse knew or ought to have known that the correspondence to the FCA and the advice of Mr. McGee should not have been relied on, etc. And so the point I'm making here is simply this. The suggestion, my lords, that there is some magic in the requirement to advise on the alleged commercial implications of running a CIS is misconceived. That particular element, that add-on to the case, makes no difference because on the claimant's own case, Mr. Woodhouse understood those matters. Next point, next problem with the claimant's approach. And I'm adopting this from the perspective now of loss. I'm looking at it from a different perspective. It is critical here to emphasise that what we are talking about here, these sales commissions and the like, is ex hypothesi bona fide arm's length expenditure. That is the premise. Payments at market value for genuine goods and services. It follows, as a matter of economic reality of the transactions that we are now talking about, that the claimants received full consideration for that expenditure. They have not suffered a loss. In just the same way as when I pay for childcare and I exchange cash for services, I have not suffered a loss. In any sense of the word, they have received full value for these payments out, whether in the form of professional services, real estate if they've purchased real estate, construction if they've refurbished. The economic effect of these transactions that are now so heavily relied upon is neutral. That is a crucial feature which in and of itself completely unwinds this argument. The next point here, I may be coming across a point I've already made, is that this aspect of the claimant's case is premised on that statement that we saw in their skeleton. These schemes were intended to be profitable on the long term. I think I've made this point. But the way it's put is, well, sometimes businesses fail on their merits. And if we failed before we reach profitability, well, that's on you, Lupton Fawcett. Well, as you know, I firmly reject, and I've already addressed the suggestion that my client would be liable for the consequences of a business failing on its merit. It's not right. But there is a yet further point, and again, maybe, and I apologise if I'm going over old ground, but this world that they base themselves on here is not what has happened. There has been no legitimate business failure. There has been no problem just before the businesses could reach profitability. Their own case is that these businesses could never be profitable. And it's because of the fraud. And it is not alleged that we owed a duty to guard against insolvency or solvency risk caused by fraud. And not alleged that we could have anticipated that possibility, let alone owed any duty in respect of it. So the thing, and I use the expression of Lord Sumption and BP, which I'll show you, the thing, which is it is alleged we owed a duty to guard against, even putting it at its very highest, commercial consequences of running a CIS, has not eventuated. I stress that my clients don't accept, as I've explained, that it would be within the scope of their duty anyway, but it has not eventuated. This is not a business that could have been profitable in the longer term. This is not a business that has failed for non-fraud reasons. And I can just close with this to ask, well, what would that have looked like? It would have looked wildly different. It would have been a business that was investing money properly. It would have been a business generating revenue. It would have been a business with assets. It would have been a wholly different proposition. would have been a business that in the longer term would have been profitable and solvent. My lords, I now propose to address you on the authorities, if that's convenient. And I will take them almost in chronological order, not quite. I won't go to all of them for obvious reasons, but I will identify my submissions on them where I don't. My lords, Samco is of course one of the founding cases in this area. In some respects it has been superseded by BP and MBS in particular. And in particular, so far as Lord Hoffman introduced the language of advice cases and information cases, that language is no longer in use. I'll come back to that. But it is a useful starting point. And we can pick this up in the bundle of authorities, please. That's tab 5. Now, I'll pick this up, please, at page 97, using the numbering on the bottom right-hand side. Actually, 96, please. Now, at 96, against the letter H, Lord Hoffman refers to the book by Hart and Honoré, Causation in the Law, around the possibility of having a rule that you are liable for all of the consequences that flow from your wrongful act. And he says at the top of 97 that that is not the normal rule. And he refers here to the case of the Empire Jamaica. So the normal rule, just pausing there, is not to shift onto the wrongdoer the whole risk of consequences, which would not have happened but for the wrongful act. Now, you'll see what he says about the Empire Jamaica. And if I may just make some brief submissions on that case, I will just deal with it here, convenience. My lords, it's a useful case by way of illustration. It's a case, the Empire Jamaica, involving a collision at sea between two vessels. I'll just summarise it for you briefly. My lords, it was common ground that the collision was caused by the negligence of one particular crew member on the Empire Jamaica, on the vessel called the Empire Jamaica. And that individual, called Sinon, was an uncertificated, although experienced and competent sailor. And the error he made in driving the Empire Jamaica into the other boat was described by the trial judge, or described, I think, in the appeal decision as a startling error. And you'll see Lord Hoffman quotes that. My lord, the question in the Empire Jamaica was whether the owners of that vessel should be liable. That turned on a somewhat esoteric question of whether they were at fault within the meaning of the relevant Merchant Shipping Act. So, of course, it's a case that arises in a particular context. But the principles that arise and that Lord Hoffman refers to are of broader application. And as Lord Hoffman says, it's clear that had that individual not been on board, the accident would not have taken place. And my lords, this is interesting because it's relevant to this case. The involvement of that individual on board was associated with a breach of regulations. The vessel had embarked on the voyage in breach of regulations which required a particular number of crew members on board to be certificated. This is the certificate point. Because of the size of the vessel, they needed to have 3 people on board who were certificated. They had 2 such people, Sinon, the 3rd crew member, was not certificated. So the vessel embarks in breach of regulation. And my lords will see the analogy with the present case. But by analogy with the present case, the breach of regulation was not sufficiently causally related to the loss. Even though, yes, if the regulations had been respected, the collision would have been avoided, the reason for the crash was because Sinon made a startling error of driving. The lack of a certificate, properly analysed, was not the reason the boat crashed. And my lords, the present case is a fortiori. The present case is analogous to a situation where the experienced sailor has deliberately crashed the boat. That's the fraud. He's deliberately crashed the boat. And the crash in this case and in the Empire Jamaica has nothing to do with the breach of regulations. It may be true for the assumptions we're working on that but-for causation might be satisfied. But that doesn't mean that the breach causes the loss. Now, it wasn't a case, the Empire Jamaica, involving professionals, and so one doesn't use the language of scope of duty, which in any event only really emerges in SAMCO. But it's expressed in the language that you see there and which Lord Hoffman describes. You could have described it as a Novus Actus case as well. And you see Novus Actus as being one of the factors that the Supreme Court identifies as relevant in MBS. My lords, SAMCO itself gives rise to a similar analysis, which is why Lord Hoffman refers to the Empire Jamaica as the starting point for his analysis. I'm not going to dwell on it further. We've done the Mountaineers Law already. Safe to say this, Lord Hoffman notes in SAMCO that there may be an exception around being liable for all of the consequences if you are accused of fraud. There's no such allegation here. It's not a Smith-New Court case. Next case I'd like to go to, please, is Galoo. This is at tab 4. So I'm moving slightly back in time. SAMCO was 96, Galoo is 1993, Court of Appeal. Galoo is a strikeout case. It was suggested that I think that Stamford might be the only strikeout case, or Saddington's, I can't remember, but Galoo also is a strikeout case. Tab 4, page 45. Now, what happened in Galoo is that Company 3, Claimant 3, has bought shares in Company 2, which is the immediate subsidiary, which in turn is the immediate parent company and whole parent company of Company 1. So you have a chain, a fairly vanilla corporate chain. C3 has bought shares in C2, which owns C1 below it. These claimants, these companies, sue a firm of auditors. And they alleged that the auditors had, prior to the purchase of shares by C3, negligently failed to discover inaccuracies in the accounts. In fact, as you can see from the report, and for reference, it's internal 1367H, that the inaccuracies were fraudulent misstatements by officers of the company. The companies alleged that had the discrepancies been identified, the companies would have ceased to trade immediately and subsequent losses would not have occurred. You see the parallel with this case, ceasing to trade. The deputy judge struck out the claims. A much smaller separate claim on a different basis was allowed to proceed, but it's not relevant for these purposes. I'm focusing on the claims that were the substantive ones which were struck out. And you can see the holding at the bottom of the footnote held dismissing the appeals that the mere acceptance of a loan, there was a loan here as well, could not amount to a loss causing damage, and the acceptance by the first and second plaintiffs of loans from the third plaintiff in reliance on the defendant's statements, therefore give no rise to no cause of action. One sees that referred to later in Saddington's. That a breach of contract would sound in damages only if it were the dominant or effective cause of the claimant's loss, and not if it had merely given the opportunity for the loss to be sustained. And here, because we're pre-Samco, we see the language of dominant or effective cause in the same way that in some of the other cases, I think it's Saddington, we're going to see fair, just and reasonable and foreseeable. The court's using different language to express the same ultimate concept, which is where should the risk fall? And those principles apply squarely to this case. The receipt of investor funds was a benefit to these companies. It doesn't give rise to a loss. And the loss arises in what happens afterwards, which is not the professional's responsibility. The advice given by the professional only provides, at best, the opportunity for this. And we can see it further if we turn into the report, please, at page 53. And against letter C, just above the first hole punch. Paragraph 19 alleges that in auditing the accounts of Blue and Gamine, DG acted negligently in breach of their duties. And you can see the quote from the pleading, and they say that had the accounts effectively been accurate, it would have shown that the companies were unprofitable and worthless. The insolvency would have been revealed, and those companies would have ceased to trade immediately. They would not have accepted advances. And you can see at 20, next to the second hole punch, paragraph 21 pleads that Blue and Gamine suffered loss damage as a result of continuing to trade after they otherwise would have done. You can turn over to page 54. And just below the letter D, Lord Justice Glidewell says, I entirely agree with the Deputy Judge on this issue. Like him, I do not understand how the acceptance of a loan of itself can be described as a loss causing damage. The same applies, my lords, in my submission, mutatis mutandis, to the receipt of investments from investors. If anything, it is a benefit to the borrower. Of course, a loss may result from the use to which the loan monies are put. But no such resultant loss is pleaded. That's true in this case, true in the present case, and even if it were, it might very well be difficult to attribute it to BGM. Same in this case. I therefore agree with the Deputy Judge. And can I add that
when you say no such resultant loss is pleaded, one of the things that Mr. Pickering relies on is the use of the money immediately and unavoidably to pay sales commissions and so on. And he says that gives rise to an immediate deficiency, because you get the 100,000 in, but you don't actually get a net 100,000. You only get 86,000 or so. So there's a question as to whether that's pleaded, which I would like to hear you on. But subject to that, it is said that some of the money that came in is immediately lost.
And that is not within the scope of my client's duty of care and not alleged to be.
Yes. What I want to know is whether your answer to it is, you've already given one answer to it, which is they got good value for it.
Yeah.
There are two other possible answers to it. One is the one you've just said, which is there's nothing to do with me. But there's also another one, which I think was the judge's approach, which is, well, it's not pleaded as a loss. And it clearly was in APOC 6, sought to be pleaded. Is it pleaded in APOC 5?
No, there is I accept that there is a reference by way of background to sales commissions of 12.5%, but there is no claim advanced against my clients in respect of that amount. The claim, and we'll go back to it in due course, is for the monies paid in by investors less a coupon already paid to them. That is it.
Okay, thank you.
There were liquidation costs and secured loans, but that's all been abandoned, so we don't need to be troubled with that. So I wanted to add this, that in Galoo, it was alleged that the auditors should have detected the fraud. They should have detected the fraud. Even then, the auditors were not liable for what followed from continuing to trade.
And even if they had produced accurate accounts, the company would have stopped trading.
So,
Yes, but that is analogous to you should, it is said, have identified this was a CIS, and had you done so, you should have told them to stop trading.
that's the but-for point. That's
Yes.
the but-for point.
Yes.
I'm addressing it as, or intending to address at least a slightly different point, which is even in Galoo, the scope of the duty was said to include detecting the fraud. If I can use the language of scope
Yep.
of duty,
Yep.
I appreciate that wasn't the language that was in ordinary parlance at the time. But even then, the Court of Appeal rejected the suggestion, even with but-for causation satisfied, and even with the allegation that the auditors should have detected the fraud, they were not responsible for the trading losses that followed. There is no, this case is a fortiori, no allegation confirmed that we should have detected the fraud. So, my lord, at F and G, you can see the case developed, and then it's concluded ultimately against the claimants, and the case is struck down. We then turn to Saddington's.
I mean, they rather unfortunately adopt ultimately a test of common sense, which is disapproved of in Edis, because one judge's common sense is another's nonsense. But it's really a prefiguring of Samco.
It is a prefiguring, and one sees the same in Saddington's, which I'm about to go to. That the court's striving to achieve a fair allocation of risk. Maybe I'm a little bit of a simple thinker so far as these matters are concerned. When I first learnt about tort law, it was about proximity and fair, just and reasonable and the like. We're now talking about the six-part test and MBS. But as the Supreme Court said in URS and BDW, they said it's all about striving to work out proper allocation of the risk. And where but-for causation may be satisfied, nevertheless, that's not enough. And so some cases have described it in terms of fair, just and reasonable, or Lord Justice Glidewell used the expression of common sense. But one sees a theme in the case law that the professional is not to have ascribed to them the consequences of commercial decision-making that follows from their advice, where they did not take any responsibility for such commercial decision-making.
Yes. You wanted to go to Saddington.
Saddington's, tab 6. It's decided a year before Samco. My lords, I know are familiar with this case. The report, though, does not come out for 3 years, which is why in the authorities bundle it's found after Samco, but in fact the decision predates Samco by a year. So Galoo was a strikeout case. Saddington's is a strikeout case. You'll know the facts, my lords. £175,000 was borrowed on the strength of a valuation from surveyors. 75,000 was used to extinguish the existing mortgage, no loss there. 100,000 invested in the husband's business, which subsequently failed. And that sum was claimed by the plaintiff from the valuers on the basis that had they not overvalued the property, this loan would not have been made and the loss would not have been suffered. And it was struck out by the Court of Appeal. In the head note, page 109, top right-hand corner, shows that the Court of Appeal approached it in 3 different ways as a matter of analysis, all of which had the same result. Held by the Court of Appeal, 1, the only damage pleaded was the execution of a mortgage. Although it was pleaded that the remaining 100,000 was advanced to the husband and this was lost, it was apparent that the advance could only have been made with the consent of the plaintiff. any subsequent loss resulting from the use to which the loan monies were put could not be attributed to the defendants. I say the same applies here. 2. If the damage alleged was merely the creation of the mortgage, there was no damage. If the damage alleged was the subsequent loss of £100,000, it was not damage of a kind which the first defendants could or should have foreseen. So we see the language of foreseeability, and it was not fair, just, and reasonable to make that defense large. The same result would be achieved if the matter was approached as a matter of causation. If there had been a breach of duty by the first defendants in overvaluing the property, it did not cause the loss of the £100,000, it gave the opportunity for that loss to occur. Galoo followed. Now, in my submission, all of the same reasoning, recognising that this is pre-SAMCO, pre-MBS, pre-BP language, the same reasoning applies. And I just want to show you some specific passages, please. I'm in the judgment of Lord Justice Falcon. I'm at page 111. I'm in the left column, just below the second call punch, which I appreciate may be of no use to my Lord Justice Edis, who's using an electronic version. So it's 2/3 of the way down. You will see the judgment says this: from this and from the leading case of Caparo Industries and Dickman, I derive the following propositions relevant to this appeal. 1. The law should develop novel categories by incrementally. 2. There is no duty to take care in the abstract. Duty is to avoid causing, and this is anticipating, it might be said, SAMCO and so on, causing to the particular plaintiff damage of the particular kind which he is in fact sustained, the duty. So you see there the need for the relationship between the duty and the loss. In every case, the court must consider not only the foreseeability of the damage and whether the relationship between the parties is sufficiently proximate, it must also pose the question: in this situation, is it fair, just, and reasonable? The law should impose on the defendant the duty of the scope suggested. And then he refers to Galoo and the acceptance of a loan, which I say, mutatis mudandis, applies to investor receipts. There's no difference conceptually between those two things. And reading down, the judge said this: applying these principles to the facts as pleaded in the statement of claim, I am satisfied that it discloses no cause of action. The only damage pleaded is the execution of a mortgage as security for a loan of £175,000, of which £75,000 was used to discharge the existing liability. Admittedly, it is pleaded that the remaining £100,000 was advanced to Mr. Saddington and this was lost. But it is apparent that advance can only have been made at the direction of and with the consent of the plaintiff. My lord, the same applies here. The use of these monies, whether for sales commissions or Ponzi schemes or anything else, was made by the claimants as their decision. Any subsequent loss resulted from the use to which the loan monies were put, which cannot be attributed to the first defendants. Indeed, it is not so pleaded, nor is it so pleaded in this case. And he then says this, I'll just show you this, if I may. I'll go back to paragraph 5, Roman 3 of the amended statement of claimants, please. The first defendants, we all should have known that if the first defendant's valuation was excessive, the owners of the said property in proceeding with the loan in the said mortgage would be subjected to a liability which might, and then the judge says, so we know in the judge's words, and I stress the word might, mature into a substantial financial loss. Now, let me pause there. There is no such pleading in this case. But even if there were, it doesn't work. Because this is, my Lord Justice Holgate's parallel universe that never came to pass, that these businesses might have failed for non-fraudulent reasons. They might have failed for non-fraudulent reasons. Not only is that not within the scope of my duty, but Lord Justice Balcombe says might is not good enough. I mean, even putting to one side the showstopper, that is not what happened in this case. It's not good enough analytically. In my judgment, this action must necessarily fail. If the damage alleged is merely the creation of a mortgage security, that is no damage. if the damage alleges the subsequent loss of 100,000, it is not damage of the kind which the first defendant could or should have foreseen. To make the first offence liable, that would be unfair, unjust, and unreasonable. I would have reached the same result if I'd approached the matter of one of causation, and what goes on. And they distinguish the decision in Forster and Outland on the basis that in Forster and Outland, the mortgage secured loans over which they had no control, which is not our case and was not the case in Sanity. Now, so we then, in the chronological sequence, my lords, we then have the Haugesund Kommune case, a 2011 case. I won't take it to you separately because it's referred to in BPE, and I'll refer to it there. We then come to Stanford Bank. This was another striking case. I appreciate that my Lord Justice Nugee was the first instance judge in the case. It was again a case involving a Ponzi fraud. Mr. Allen was alleged to have operated a Ponzi fraud for a number of companies, including Stanford International Bank. The bank goes into liquidation, brings a claim on the quint-scare duty it claims it's owed by HSBC. Now, pausing there, the law on the quint-scare duty has moved on, but what matters for present purposes is they were alleged to have breached their duty. They should have spotted that this was a Ponzi scheme, the bank. They should have realised. They should have closed the gate on the bank account earlier than they did. And in the meantime, 116 million has gone out to pay bona fide debts. And it was said that has caused the bank a loss. Now, you will note again the contradistinction with this case. It is not alleged in this case that we should have appreciated there was a fraud. And I will come back to the significance of that. Now, the Chancellor, with whom the remainder of the Court of Appeal agreed, concluded that SIB, Stanford International Bank, had not suffered a loss because the payments out, 160 million out, had extinguished existing liabilities. And that was upheld by the Supreme Court. And we say, my lords, the judge, Mr. Justice Sheldon, in these proceedings was right to conclude that in this case, as in Stanford Bank, the net asset position is substantively unaffected by the advice we gave. The claimants received the money, and they can only be liable to reimburse what they have actually received. The balance sheet effect is neutral. And in the same way, the same applies to any payments to sales agents or solicitors for the reasons I've given. Now, in Stanford Bank, it was right that certain creditors, the people who hadn't got their money back and who proved in the insolvency, lost out as a result of what I might informally describe, as a preference to the prior creditors. And if I understood my Lord Justice Nugee's first instance judgment correctly, it was that was one of the features that troubled the court at first instance. And the Chancellor resolved that point in this way. The bank, HSBC, does not owe a duty to the creditors. And there is obviously a parallel there with this case, because my clients do not owe any duty to any creditors or investors. But there's a further point by way of parallel. Because it was alleged in Stanford, or perhaps by way of contrast, because it was alleged in HSBC and Stanford that the bank should have spotted the fraud, the Chancellor contemplated how the claim could have been expressed. And you can see this at page 190 of the Bible. Paragraph 29, the judge refers to the start claim made. And HSBC performed its quint-scare duty to close the bank account on detection of fraud or suspicion of fraud. The Chancellor said, it is of course plausible to imagine consequential losses that SIB might have sustained as a result of the failure to freeze the accounts by the relevant date, but no such losses form the subject of this issue. Again, in this claim, no such losses are claimed. Secondly, paragraph 30, the Chancellor says this, moreover, and perhaps more importantly, SIB does not claim that its net worth was less as at 17th of February 2009 when it did freeze the accounts than it was at 1st of August when HSBC says it ought to. And the Chancellor says this, it might seem that a company operating a Ponzi scheme would be likely to have greater debts as time progressed. Now, the reason that might have been conceptually an available approach in HSBC was because the bank was said to be under a duty to guard against the fraud. That was how the Quintscare duty was expressed and understood at the time. In this case, there is no such allegation, and I've shown you the confirmation that there is no such allegation. So this formulation of an alternative loss measure is not available to these claimants because they accept there was no duty to detect the Ponzi scheme. So there is no claim on that basis, none is available, and there is no claim for consequential losses, the call centre or whatever it might be. And the correct characterisation of the loss is that they're unable to pay because of the fraud, which is not within the scope of my client's duty. The next case, please, is BPE.
Sorry, which case?
BP, Hughes Holland and BP solicitors.
Oh, that was handed in loose.
It's a loose. It's a.
Yes.
I've added it to my bundle. Effectively, is an informal tab 14. We can make arrangements for that. Again, if that
Don't worry.
When was it? Yes.
I've not seen it, I'm afraid.
Well, I got it, but I don't now know where or when I got it from.
I haven't seen it. What is it called?
It's called Hughes Holland and BPE. It was sent in by email by our clerks on Monday.
Yes.
Normally,
We should have hard copies of it. Do we have hard copies? Oh, we have hard copies.
thank
Yes. Thank you very much. Problem solved. My Lords, what you have before you is a decision of the Supreme Court handed down in March 2017. It is the last but one significant judicial pronouncement on scope of duty points. My Lord, let me summarise the background. Like the present case, it was a claim against solicitors in relation to advice upon and the drafting of legal documentation relating to a loan for a property investment. As in the present case, it was not alleged that the solicitor was to advise on the viability of the scheme. And you can see that in the head note. I'm just between letters D and E. The defendant solicitors were instructed, it says, not to advise the claimant as to the viability of the scheme, but to draw up a facility letter and a charge over the building. And then there was an error, which allowed the transaction to proceed where it would not otherwise have proceeded. So but for causation is satisfied. The transaction, as in the business investment, was a failure. I'm now reading from the head note again, and the claimant lost virtually all his money. The judge had allowed the claim, the Court of Appeal allowed the solicitor's appeal. And I'm reading from the bottom of the introductory section of the head note next to the letter G. The Court of Appeal, allowing the solicitor's appeal, concluded that the development project had never been viable, again striking parallels with the present case, and that the whole loss was attributable to the claimant's misjudgments, and accordingly reduced the damages to nil. And then there's an appeal to the Supreme Court, and it's dismissed. And you will see how it's described there. Now I'm just going to focus on the key parts. I recognise that the court will read these judgments in its own time. If we can pick it up, please, at I'm using the numbering in the top right or top left-hand corners, page 623, 622 and 623. I don't know if my Lord's versions are double-sided. So if we can open up please 622 and 623. And Lord Sumption here, who gave the main judgment, is dealing with criticisms of Samco in the reasoning of Lord Hoffman. And I'm on page 622. And here we see the distinction between what the approach now taken, which is to distinguish causation properly understood from scope of duty. And he says, if the Samco principle is to be classified as a principle of causation, it is certainly not directed to that question, as the House of Lords pointed out in my credit. The question which it poses, and I emphasize this, is rather whether the loss flowed from the right thing, i.e. from the particular feature of the defendant's conduct which made it wrongful. Now, in MBS, the Supreme Court described that sentence as cryptic.
Could you just tell me where it is, please?
I'm sorry, my Lord, it's 622, between the letters G and H on the right-hand side. So,
Yes, thank you.
but for my part, my Lord, maybe it's just me, but I find that quite a helpful way of putting it. Is the loss, is the harm that's eventuated, the thing which we were to guard against? The harm that's eventuated here is the fraud and all the consequences and the unviable schemes and the fact that they continue operating, continue generating deficits, no revenues coming in, money's being stolen, you end up with a massive deficit. That's not the thing which we were under a duty to guard against. At 39, Lord Sumption deals with the language used by Lord Hoffman in Samco, where Lord Hoffman distinguished between advice and information cases, and that distinction has been now put to bed. Lord Sumption explains that effectively these words can give rise to confusion, and that information given by a professional man to his client is usually a specific form of advice. In other words, where professionals are involved, it's always a kind of advice. So trying to characterise something.
I think it's an unfair criticism of what Lord Hoffman said, because he distinguished between information which was just one of the bits of information you relied on, and advice as to whether to enter into a transaction at all, which seems a perfectly sensible distinction.
Well, that's what Lord Sumption goes on to explain. It may be one of those cases of people re-explaining concepts in their own words. When
I suspect it's a criticism of counsel who use the labels advice and information and try and make them fit their case without really looking at what Lord Hoffman said. But anyway,
I'll take the hit on behalf of counsel if necessary.
It's their job to twist the words of judgments in their favour.
And one can see why you would, and maybe that's what Lord Sumption is saying. These words are liable, maybe not to mislead, but to being misused.
Yeah.
And he addresses that at 40 and 41. He, if I may respectfully say so, he says exactly what my Lord says in terms of distinguishing between those two things, where you are providing advice, I'll use that word, on a particular aspect, or whether you are taking responsibility for the decision whether to enter into the venture. That's the distinction that Lord Sumption draws at 40 and 41, which is the distinction that Lord Hoffman was pointing to in Samco. And it is only where you take responsibility for the decision whether or not to enter into the commercial venture and to consider all relevant factors, and indeed to consider what is and isn't relevant, that the commercial consequences will be visited upon you. By contrast, in what is described in 41 as an information category, the professional advisor, and I'm reading now, contributes a limited part of the material on which his client will rely, and so on. The overall assessment, and I emphasise that the commercial merits of the transaction are exclusively matters for the client. In such a case, Lord Hoffman explained in my credit, the defendant's legal responsibility does not extend to the decision itself. He is only liable for the financial consequences of its being wrong. This is back to the certificated point and the sailor in the Empire Jamaica. And it was Lord Hoffman says, only wrong for the consequences of him being uncertificated. Otherwise, and I emphasise, the defendant would become the underwriter of the financial fortunes of the whole transaction by virtue of having assumed a duty of care in relation to just one element of someone else's decision. All of that squarely applies here. And that the claimants accept, and I've shown you the passage in their skeleton where they accept, that we are not the underwriters of these schemes. We did not take responsibility for the decision whether to proceed with these transactions. And over the page, 624, Lord Sumption refers to the judgment of Lord Justice Ricks giving the leading judgment in the Court of Appeal in the Halverson Commune case, which we refer to in our skeleton. And you can read what is said there, you can read what is said in our skeleton on the topic. We say it squarely applies here. That was another claim against solicitors. It failed. And the application of the facts to the case comes at the end of the judgment at paragraphs 54 and 55, page 629. It's the last page, the last physical page, penultimate page of text, paragraph 629. And the result is the solicitor is not liable. And the same outcome applies here. It's a very instructive case for you to do because it is a case relating to solicitors. Now, finally, my lords, MBS. This is my last submission on the authorities. This was a claim, as you know, by Manchester Building Society against a firm of accountants, Grant Thornton. I'm sorry, it is at tab 11. Claim by Manchester Building Society against a firm of accountants, Grant Thornton. And allow me, if I may, to summarise and possibly slightly simplify, but hopefully not emasculate the facts. The Building Society was considering entering into some swaps contracts, which it considered would be desirable to enter into to manage its financial position. I appreciate I put that at a high level of abstraction, but I think it's sufficient for present purposes. They asked Grant Thornton to advise on the regulatory treatment of those swaps from a capital adequacy perspective. Because
I'm not sure that's strictly true. I think they asked them to advise as to how they should be treated in the audited accounts,
yes.
which had a consequence for capital adequacy. But I think they were advising on capital.
No, it was how would they would be treated for accountancy purposes, for the purposes of understanding the impact on capital adequacy and compliance with regulations. I anticipated I might be summarising too far, and I've become it. And depending on how the swaps fell to be treated from an accounting perspective, it in turn affected the level of capital that the Building Society needed to keep in reserve to guard against the volatility of these instruments. And Grant Thornton gave advice on that. And on that basis, the building society proceeds to invest in the swaps. Several years later, it is discovered that Grant Thornton's advice is wrong, and that the accounting treatment that they had indicated was not correct. And the effect was that greater capital needed to be maintained, and otherwise, the building society stood to be in breach of its regulatory requirements. You see the regulatory parallels. And so, to avoid this, the building society has no option but to break the swaps, to exit them, to return within an acceptable level of capital adequacy. That's my summary. Now, due to the volatility in the markets, the value of the swaps had gone down. And so when the swaps are traded, the building society makes a mark-to-market loss. And the Supreme Court held that that loss was recoverable from the accountants because it was directly connected to and within their duty of care. The very issue upon which they were required to advise had eventuated. In Lord Sumption's words, the very thing arose. It was discovered that the accounting treatment was different from that which had been advised. The capital adequacy problem which they were seeking to guard against eventuated, and the only way to resolve it was to break the swaps. So there is a direct nexus between the duty of care owed and the loss. And my lords, on the facts, it is an instructive case by contradistinction. In the present case, the regulatory issue that we are said to have advised has not been visited upon the claimants, nor caused them to do anything. And it has not increased the financial burden they already have. Or put in simple terms, the collapse of the schemes had nothing to do with the regulatory issue. It's the complete opposite of MBS. And in MBS, I just note for completeness that at trial, a contributory negligence argument had succeeded against the bank. The bank had been too ambitious with its swaps, and that wasn't something that Grant Thornton were responsible for. So you'll see reference in the report to a 50% deduction there. Now, I just want to show you a couple of passages here. I won't take long with this. I'm not going to go into the analysis of the facts. I've explained them and my interpretation and submissions in there. Page 204, if we could start at page 204, please. It's paragraph 6. You were shown this yesterday. These are the series of questions that the Supreme Court said arose. They refer here to Lord Sumption's judgment in Hughes Holland, which I've taken you to. My lords, we rely in particular on questions 2, 5, and 6. And I would diffidently suggest that 5 and 6 might in some circumstances be two sides of the same coin. 5 is the nexus, and 2 is questions of remoteness, foreseeability, effective cause, novus actus. And sometimes a harm might be outside the scope of duty because it is too remote or unforeseeable. There might be overlap between those two. And indeed, my lords, and I'll just say this for completeness, so you have it. In the Court of Appeal decision in that URS case I mentioned earlier, the Court of Appeal has said these should not be applied as some kind of test by rote. It's more a sanity check. And now turning forward in the decision, paragraph 8, please, at page 205. what's said here. The second question addresses the scope of the defendant's duty and is the central question in this appeal. The fact that the defendant owes the claimant a duty to take reasonable care in carrying out its (brackets the defendant's) activities does not mean that the duty extends to every kind of harm which might be suffered by the claimant as a result of a breach. They refer to Spark and Steel, and then Caparo and Dickman against the letter E. Similarly, in Caparo Industries and Dickman, it was recognised that although the auditor of the company's accounts owes a duty of care to shareholders in the company for some purposes, breach of that duty does not mean that the shareholder claim damages. And now, an important bit, for loss flowing from its reliance on the audited accounts to make investment decisions. And investment decisions will include being sales agents, deciding to invest in real property, running a Ponzi scheme, misappropriating, running an unviable scheme that is never going to generate profit, even in the long term. My lords, that was what I wanted to say on the authorities. My lords, I'm in your hands. We could break now and start again at 5 to 2, and or we could carry on. I'm now going to address you on bringing the submissions together on the individual heads of loss that are now tabled.
I would carry on.
Very well then. My lord, what we now face is a claim that appears to be divided into 3. The first is the claims in respect of what is described as immediately incurred liabilities. The second is what's described as other expenditure. And the third is the section 26 commission. 26(2)(b), sorry, compensation. On the third, none of those claims, as now advanced on appeal, is found anywhere in the pleading. None of them. In a sense, I can't turn the pages of the pleading to show you because it's not there. But what I can show you is what is claimed. It's in the supplemental bundle. Tab 7, page 222. It's paragraph 173. By reason of the above, the asset SPVs have suffered the following loss and damage. And there's a list of the companies and the amounts, so the total at the end. The other losses, liquidation costs, loans are all now abandoned. So this is all we're interested in. And they say further particulars of the above losses are set out in Schedule 3, attached to these particulars of claim. And that's where we turn up, please, the landscape spreadsheet, page 273, which you've seen before.
The total given in 173 is 63 million. I thought we were talking about 68 million. Is there an explanation?
I think 68 is the total investor funds raised when I look at the spreadsheet. And then when you give credit for the coupons that have already been paid,
I see.
you end up with 63.
Thank you.
Was the 63 at the bottom of the column about 5 in from the right?
Exactly. So that's what's described as estimated investor loss. And it is expressly pleaded as...
What is this? Is this the Schedule 3?
That's my understanding.
It's not headed anything.
No. This is what's been included by the claimants in the supplemental bundle as their pleading before Sheldon J.
Yes.
Sorry, Mr. Justice Sheldon.
So we see the 68 million under total investor funds raised, and there's 4.6 million of returns paid, leaving 63 million
yes.
estimated loss. And that's now being cut down because of limitation, which is the remaining
to 48
columns.
And there is no claim for what's described as immediately incurred expenditure. There is no claim.
Well, if that's a reference to the 12.5%
Yes.
sales commission.
Yes.
But I think it's said that, if I'm correct, section 26 applies, and subsection 2 applies anyway, because there is this immediate liability to reimburse effectively what was the 63 million, now 48 million.
I think that's right, but they recognise, as I understand it, that they have to come up with a different formulation because they've had that money. So they now need to explain where it's gone, and they need to hold us liable for that.
But I think
I'm
the way
I may be struggling because
Mr. Pickering put it was they haven't had the money. They've only had 86% of the money because it's a necessary consequence of someone paying 100,000 in, that 12.5 or 13.75 or whatever goes out.
It comes down to pages 8 and 9 of the skeleton we were looking at yesterday. As my lord says, you have the use of the money, and then there's also the additional pound for pound point. But it's when you add in I think I follow where you're going. It's when you add in the 12.5% sales commission, immediately incurred liability, that you go negative.
understand that. Now, I've made the pleading point. My lord, you asked me what's the pleading. I've shown you. If it's being said we have a liability for the 12.5, I'll now meet it on the substance.
Well, it certainly doesn't plainly leap out at the pleading.
It was an observation that I don't think it's just me. Lord Justice Stingerman's made a similar observation.
Yes, well, that's why they pleaded it out in APOC 6.
Now, and I think we quoted the relevant extract of the transcript in our note on the amendment application. That's the pleading. Let me turn to the substance, and here I'm grouping together and bringing back in a number of the points I've already made. This head of loss suffers from many of those problems. 1, not within the scope of my client's duty to advise on the use of money once received and not alleged to be. 2, this money belongs to the SPV. Once paid in by the investor, it makes no difference whether it's paid into a solicitor and held on client account on trust, from which then there are then disbursements. It is the SPV's money. The SPV, the company, the claimant, has had the money beneficially. The manner in which whether it goes into a solicitor's account or their own bank account is immaterial.
Strictly speaking, when it's paid by the investor to the solicitor, it's held in escrow pending completion of the transaction. Once the transaction is completed, the solicitor no longer holds it in escrow, but holds it for the SPV. And then whether it actually reaches the SPV or whether the solicitor disperses the disbursements, it disperses the disbursements on behalf of the SPV.
Absolutely. That is the correct analysis, if I may respectfully cease. Because as soon as the money is moved from escrow to client account, it becomes SPV money. So that is a further point. Another point is that my Lord Justice Nugee is right, that the payment to the sales agent arises pursuant to a pre-existing agreement. I recognise that the liability to pay may not have fully crystallised until the sale goes through, but the contractual arrangements which give rise to that liability are put in place ex ante, necessarily so.
I'm sorry, what does ex ante mean?
Sorry, before the transaction takes place.
Thank you.
Bringing us closer to Stanford. Next point bringing again together points I've already made. This is legitimate expenditure, bona fide expenditure for full value, for professional services. No loss. So I've made the scope of duty point, I've made some other points on the correct analysis of the payment, but there's also full consideration. And then the next point...
Would it matter if it weren't? I mean, suppose one of the things solicitors have done is pay a commission to Mr. Woodhouse of 10%, which was really not for any services at all. Would that make any difference?
Not to the scope of duty analysis, no.
It might make a difference to whether there was a loss.
It might do.
Yeah.
In the same way that if I pay for to take my childcare analysis, I pay for childcare and I get no childcare. But that's not their case. I really want to stress that. The payments we're talking about here, which it said my client is somehow liable, are bona fide payments, full value, at arm's length. That's their case. And then the next point, and again I offer my lords a menu of options. The next point is that there is no immediately or automatically incurred liability to an investor under section 26. And that, I did say yesterday I would come to later in my submissions. But that is an essential building block. I won't develop the point, I'm conscious of the time, my lord. It is an essential building block of the way the claimants now frame their case.
Well, I'll leave you with this thought, which you can come back to at 2 o'clock. You may well be right that the Section 26 liability is contingent on the investor exercising their right. But if it was a CIS, then from day one, they had a statutory right, which they could exercise if they wanted to. So it might not be immediately payable, but it might be an immediate potential liability. You might like to think about
At best contingent.
Yes.
At best contingent.
We'll say 2 o'clock.
All rise if able.